Good afternoon, ladies and gentlemen, colleagues. In the exceptional address by President Yusuf, he spoke of the many ways in which engaging with international law could be understood, and he addressed three of these in some depth. This morning and the first part of the afternoon, we've had a variety of special topic panels operating within this rubric. And we now, after the opening address of Lady Hale and the keynote of President Yusuf, do come to the first plenary session, which reverts to the overarching theme of engaging with international law. And it is this very topic that our panelists will address. International law is a process to assist those who are decision makers, courts, foreign office, legal advisors, other such decision makers for making optimal decisions in law, and also to assist others, academics, civil society, activists, in their critical assessment of such decisions. In the world of international law, the hat you're wearing is important. That is, whether you are indeed a legal advisor, a judge, an academic, a civil society activist, perhaps. It's not that there is a different international law, of course, for each of these. Rather, it's that experience, immediate objectives to a client, and other factors inevitably suggest some legitimate differences in perspective. And so it is, it seems to me, when it comes to the topic of engaging with international law. I rather suspect that the different participants in the international law system, so wonderfully represented in the diverse attendance at this conference, engage with international law in ways that are not wholly identical. How does the human rights specialist and the judge of a domestic court engage with international law? Where does specialist human rights knowledge fit into the general knowledge of international law? How does international law generally and human rights specifically fit into the framework of a constitutional court? How does a court of specific rather than general jurisdiction engage with international law? How does it decide whether the constitutive texts of that court are enough and for determining issues before it? Or is it necessary to have recourse to other topics of international law, including, of course, the UN Charter provisions? Exactly how are such questions resolved? Is the court reliant on the parties before it in raising such issues, or are they a matter proprio motu for the bench? And then the legal advisors on how is a legal advisor to a foreign office ensuring in this complicated and expanding world of international law that their knowledge is up to date and not regionally or culturally biased? And is deep knowledge and advising on it the only way of engaging with international law, or do they perceive other activities within their national countries as relevant in the theme of engagement with international law? Well, we have a marvelous panel to help us with these and other questions. Professor Vaughan Lowe, QC, will first address our topic generally. As most of you will know, he's formerly the Chichele Professor of international law at Oxford, the author of important works on international law, in these days a very full-time practitioner at Essex Court Chambers. Sir Ian MacLeod is well known to so many of us here for the approachable and supportive role he plays as legal advisor to the Foreign and Commonwealth Office, and has obviously been heavily involved in the organisation of this conference. Mara Talalian is the head of the legal department of the Ministry of Foreign Affairs of Greece. She's been in this role since 2013, so has seen all the tumultuous changes of the last years, and she was very involved in the organisation of the anniversary conference for the adoption of the additional protocols. Judge Timaika we have also with us, the UK judge at the European Court of Human Rights. Before that, he was a silk practicing at Essex Court Chambers in European human rights law, mostly, but also in other matters. And then our panel is completed by Professor Kate Reagan, formerly a judge of the Constitutional Court of South Africa, now the inaugural director of the Bonavero Institute of Human Rights in Oxford, and I'm sure in both capacities she will have much to feed into our topic. I've suggested to you the overlapping but not identical matters they might tackle in our theme of engaging with international law, but these are simply my thoughts. I've not been sharing with them as they've prepared their statements, and of course they might see their assignment as entirely different and looking at totally other issues.
Thank you very much, Rosalind. Colleagues, it's a great pleasure to be here. The theme of this conference is engaging with international law, and when I started reflecting on the topic, I was struck by how much international law has changed since I first encountered it almost 50 years ago. At that time, reading Brierley and Brownlee and Oppenheim, we learned that while each state is in principle free, there are some well-established rules concerning the making and implementing of treaties, the acquisition of territory and exchanging diplomats and so on, that no civilized state could breach, or at least no civilized state could deny. International law, we learned, was made up of treaties, many of them basically agreements between neighbors concerning particular problems of the neighborhood, and a few of them, the rather grander lawmaking treaties that had, mainly since the 1930s, started to set out the basic rules and frameworks within which international relations should be conducted. But much of international law then remained as customary international law. The state practices that were as instinctive and as rigid as queuing was once said to be for the English, and which were, for practical purposes, mostly inferences drawn from the episodes which happened to have been selected for inclusion in one of the relatively small number of published national digests of state practice that were maintained at the time. And apart from the libraries in Oxford, Cambridge and London, few of those studying or teaching in universities in this country had much in the way of access to the practice of more than a handful of states. The United States and the United Kingdom, of course, France, Italy and Germany, maybe, and maybe a few others, but to say that the view of customary international law in British universities was largely Eurocentric would be something of an understatement. It's striking that none of this, apart from the increasing frequency in the decades after the Second World War with which the grand lawmaking conventions and international organizations appeared on the scene, none of this would have appeared unfamiliar to Gentili or to Grotius, let alone to Wheaton or Holland or Oppenheim. as with so much of the international intellectual framework within which our professional formation took place, it was a recognizable extension of the framework that had prevailed since the 18th century, and in some respects for much longer than that. But things have changed dramatically, and particularly over the last 3 decades or so, and there have been major changes in the scope and the methodology of international law that have come about. As to the question of scope, the point is obvious. The emergence over the past 8 or 9 decades of human rights and humanitarian law, environmental and economic law, aviation, maritime law, outer space law, water law and energy law, all these as distinct fields of study with their own traditions, principles and personnel, speaks for itself. And it's led to a degree of specialization and compartmentalization within the study and practice of international law that is, at least in some respects, unfortunate, and which still threatens to produce, in the phrase of the International Law Commission, the fragmentation of international law. There is simply too much to read for it to be possible to keep on top of international law across the whole glorious breadth of its manifestations. And with this, it seems to me, has come about a more fundamental change in the perception of the role of international law. International law is now pervasive. It no longer provides only a limited range of templates for state action in certain fields of activity and defines only the limited constraints upon states' liberty of action, as it largely did in the middle of the last century. Now it appears to regulate all of social life. Every situation that prompts moral or political debate on the international plane is, it seems, capable of analysis in terms of law. The law has, or should have, an answer to every disputed question concerning conflicting interests in international social life. And the rule of law is not focused solely on the principle that governments and other exercises of power must be constrained in accordance with the law. It now extends to the view that all of social life is comprehensively regulated by law. And I think the rapid increase in the subsystems of international law reflects this. And by subsystems, I mean distinct groups of specialists, what academics call epistemic communities, who understand the rules and principles regulating the particular area of activity in which they work or which they study as constituting a coherent legal regime. But there's also a methodological change to which we need to pay attention, and it arises specifically from the arrival of the internet and the transformation in the availability of the sources of international law. There is now practically immediate access to the raw materials and reflections of state practice, to court reports, legislation, parliamentary debates, government press releases and newspaper reports, which were in the past difficult to locate on anything approaching a comprehensive or systematic basis. And it's not only that the obtaining of state practice is easier and quicker, a much wider range of state practice is now available. And this results from the ready access to the different national digests, which are themselves far more numerous than they were 50 years ago, and also to sources in other areas such as online message boards and chat groups, which collect, collate, and record examples of state practice which might have escaped or have been deliberately omitted from official and semi-official national digests. And this, I think, is giving rise to interesting questions concerning the extent to which courts and tribunals may take notice of or even rely upon unofficial sources and sources such as WikiLeaks. Add to that the increase in the frequency with which questions of international law are addressed in the various fora, and one begins to get a sense of the enormous increase in the volume of the sources of international law that are available to practitioners and scholars. Well, I make the simple observation that there is at present no comparable technological breakthrough that will facilitate reading, understanding, and comparing this vast repository of raw materials in order to draw appropriate inferences from it. We lack new ways of processing it. My guess is that this will lead to an increasing tendency to rely upon principles rather than detailed analyses of increasing volumes of legal materials. We may be reaching the peak of the footnote culture with articles and pleadings anchored in long lists of citations of precedents and authorities. In fact, we may already have reached the stage where it is a reasonable assumption that any proposition bolstered by a list of footnotes could, with some intensive work on Google, be matched by an exactly contrary proposition bolstered by an equal and opposite list of footnotes. Well, the obvious and rational reaction to this is to go back to basic principles, to the reasons why particular legal concepts and rules were established and have endured. And it's the confluence of these two developments, the expansion in the substantive scope of international law and the recent availability of this flood of legal materials that threatens to drown those who would previously have sought authority for legal propositions in the detailed analysis of precedents and authorities. This is what, to my mind, raises questions that go to the heart of the theme of this conference. As the scope of the subject increases, the range and number of people who are affected by it, directly and indirectly, in the course of their professional lives also increases. And naturally, they have things to say about it. They, officers of NGOs working on the alleviation of poverty and suffering or the prevention of environmental damage, industrialists, commodity brokers, police investigators, voters in municipal elections, importers, exporters, religious leaders and moralists and politicians, everyone whose occupation brings them into contact with conflicts of interest on an international scale and with value judgments on the way in which social life should be organized across nations. Everyone has interests in and views on questions that are now commonly framed in terms of international law. And international lawyers cannot and would not want to avoid engaging in conversations with non-lawyers on these matters, any more than it would avoid conversations between those in different specializations of international law. And I notice that the increase in recourse to principles rather than to a mass of precedents makes it very much easier for those conversations to take place. It will be interesting to see in the coming years how far bodies such as the ICJ and the European Court of Human Rights are willing to refer to, for example, the practice of UN human rights bodies, international investment tribunals and WTO panels, not simply as background features of the legal landscape, but as direct contributors to the development of legal principles. In most ways, this is clearly a desirable development. The wider the understanding and acceptance of rules and principles that are desirable components of the social structure, the better. And equally, the sooner that deficiencies in rules and principles that have outlived their justification or their usefulness are identified and corrected, the better. The more there are conversations between specialists and between lawyers and non-legal lawyers, the greater the coherence and the utility of international law is likely to be. But there are attendant risks. One is the risk of losing some of the finer distinctions that may be difficult to explain or to justify to non-lawyers, but which have a value, and whose loss would impoverish the vocabulary and the conceptual toolbox of international law. The distinctions between prescription, acquiescence, estoppel, preclusion, and similar concepts is one example. The distinction between questions of jurisdiction and admissibility in tribunals and other issues that may constitute preliminary objections is another. Like all specialists, lawyers have to decide how far they go in saying to others, if you want to talk seriously about this matter, you'll need to understand certain basic concepts. There is a balance to be struck between facilitating interdisciplinary discussions and preserving the accuracy and the precision of those discussions. Another risk is the temptation to think that not only can every international problem have a legal analysis, but that it can also have a legal solution or partial solution. And we need, I think, to take care to make clear that for all its immense value as an instrument, as a way of getting things done, law is only one approach to the adjustment of problems. And there are matters that may well be better left to await technological solutions or to regulation by the application of moral or political principles, or indeed to the judgment of individual states or government. Modesty and humility are valuable qualities for lawyers. One aspect of this is that the expectations of what the law can and cannot do need to be realistic. The adoption of texts on matters such as environmental protection and human rights may have very little impact in the real world, unless they're backed by careful attention to measures for their implementation and enforcement. And it is an empirical question what the impact of a given legal rule is. For example, how far prohibiting attacks on certain categories of targets, such as schools in armed warfare, contributes to the safety of children and teachers, and how far it encourages forces to situate military bases next to schools. But curiously, compared with family law and criminal law and tax law, international law is remarkably short of serious empirical studies of its effects. So, in short, I think it's likely that there will be greater engagement with international law, but that the greater engagement will not inevitably lead to greater achievements for international law or to its better development. And there will, I think, be a constant need for international lawyers to consider what the role of international law is and how best that role can be advanced. Thank you very much.
Well, thank you very much, Vaughan, for that very thoughtful analysis, which sets the scene for us admirably. So I'll ask of the panelists a start to be made for us by Ian MacLeod.
Well, thank you very much, Dame Rosalind, and thank you for all of you for being here. It's an honour to be part of this panel. And the topic is, of course, very, very wide. I've been asked to offer thoughts on how, as international lawyers for a foreign ministry, I and my colleagues understand and live this engagement with international law. So I'll offer you three personal reflections, which will perhaps prompt questions and discussion. First reflection is that as government lawyers, we engage with international law from a position of constraint. We're lawyers for our governments. We're in a client-advisor relationship with them. And this means, for example, and these are quite obvious points, but I think they are important to bear in mind, we don't choose our client. We advise the government of the day. We're not required to agree with the policies of our client. It's always open to us to leave government service and to work elsewhere. But for so long as we remain in our roles, our task is to support the government of the day in delivering its policies by ensuring that it does so within the law. It means also that we don't choose the issues we advise on. We advise on what we're asked to advise on. And in the UK, and this is perhaps a special form of constraint, which I think is very important and actually very valuable, we don't, at least in the Foreign Ministry, have the final say on the legal advice. As you'll all know, because the system is much more public now than it was when I joined the Foreign Office, the ultimate source of legal advice to ministers of the Crown in the United Kingdom is the law officers, the Attorney General and his colleagues. And the role of the Attorney General in particular on international law issues such as the use of force is much more public now than it was. Everyone these days knows that on any legal issue, it's in the news at the moment of course, the Attorney and his fellow law officers have the final say. Now, that does not mean, and I'm not saying at all, that they recklessly override or ignore the advice of lawyers or in the FCO or in the MOD or elsewhere in government. Far from it. We work very closely with their secretariat and with them in shaping advice to government, and we work very closely with external counsel as necessary. But it is important, I think, to realise that we are part of this system which delivers the legal product in that particular way. So that's the first point, where we operate under constraint. The second point is that we engage with international law in a political and operational context. I mean, at least in the Foreign Office, other country systems may be different. We rarely consider issues of international law pure and simple. It might be more accurate to say that we advise on foreign relations law, on legal issues arising within the context of the UK's foreign policy, i.e. the entire work of the Foreign Office and then stretching out into the rest of government. So we work closely with lawyers across government. National law, national politics shape the questions and shape too, to an extent, the answer that will be given. And it's not always easy to mesh the techniques, frameworks and approaches of national law with those of international law. And the question of precisely how international law has effect in the domestic legal system, and Judge Youssef mentioned the Ministerial Code and the Civil Service Code, is right at the core of our work. Third and final point is that a critical feature of our engagement with international law is our engagement with other international lawyers. So for us, international law is not just a matter, although it is that, of books and papers and principles, but of people and ideas and dialogue. And we see this in our bilateral engagement with colleagues from other ministries, when we meet other countries often on a confidential basis, but on a one-to-one basis, if you like. And this may happen in the context of specific issues, bilateral negotiations on delimitation or whatever the issue might be. But the most productive engagement is always that which comes from getting to know one's colleagues in other countries and being able to open up with them for private and frank discussions on difficult issues. Similarly, engagement in multilateral fora has the same possibility and the same opportunities. The UN, the Assembly of States Parties of the ICC, the Council of Europe, the EU. And Michael Wood has written in the work entitled "The International Law as a Practitioner and as Practitioner," International Lawyer as Practitioner, which is a publication by the British Institute in 2000, a very insightful and interesting and still highly relevant article on the dynamic of that sort of engagement. We engage too with lawyers outside government, whether in private practice or in academia. And at its best, this engagement operates to inform and challenge each side and to refine and develop thinking. In the modern world, I think that cannot happen too often. External engagement has always been a core part of the work of the FCO legal team, going back over many, many years, and it remains a key objective for us. I've personally never regretted the time I've spent being able to spend in that way. My regret in that context is more that I do not have a bigger network of contacts, because we all tend to talk only to those we know. So what we hear is an echo and not a genuine conversation, and Vaughan alluded to that a moment ago, and I very much echo that thought. So there's an obvious link in all that back to this conference. Yes, of course, we come to hear and understand the issues of law better, and we've had a remarkable galaxy of expertise in the conference today. To hear from experts in these fields, many of which lie outside, for me at least, many areas of my experience. But the great value of a conference like this, and of events like this, is to create the personal connections and the sense of collegiality and common effort and purpose which we need in pursuit of the vital and noble aim of securing the conduct of international relations under law. Thank you.
Well, our thanks to Sir Ian for that statement exactly on point, and for bringing out certain issues that otherwise might well have escaped our attention. And next I'll ask Maria Telalian how the perspective looks from the Greek Foreign Ministry legal advisor's point of view.
It's working again. Yes, thank you very much, Madam Chair. And let me start by saying that this is a great honor for me to be part of this panel, distinguished panel, and I would like to thank the organizers for inviting me. Let me also start by saying a few words about my office, the legal department of the Foreign Ministry. This department was actually created in 1931, and its main task is to offer legal advice, legal opinions in all matters related to international law, public international law, and lately to European law. And this advice is offered to the minister himself, but also to the other departments of the political departments of the ministry, if requested, of course. In addition, the legal department represents the foreign ministry in treaty negotiations, bilateral, multilateral, in litigations before all sorts of international courts and tribunals, and acts also as agent of the Greek state before the ICJ. Now, I would be remiss not to mention that in the legal department there is a legal team, an extraordinary one, with deep knowledge and expertise in public international law issues and European law. And these people are fully committed not only to the preservation of the integrity of international law, but also to its promotion. And as you understand, that makes our job both fascinating and challenging. A last point that I'd like to make about the legal department is that the lawyers, the legal advisors in the legal department are directly accountable to the minister himself. And actually this is good because it gives you the privilege to openly speak your mind to him on what a rule of international law is about, what are the requirements, what is forbidden by international law, and whether a particular government action is in conformity with that law. And this is particularly important when there are controversial government actions to be taken or are taken. But in these cases, our main objective, the legal department's objective, is to persuade our client to reconcile policy in national interest with international norms, even in these cases, in the controversial cases, as we firmly believe that public or national interests are better served, in the long run at least, if pursued on a legally sound basis. Now, let me now make a few remarks on how we engage with other lawyers, first across the government. Now, first, we engage almost every day with our fellow lawyers within the different sections of the administration, mostly regarding the compatibility of national law and policy with international norms and the dissemination of international standards. And believe me, this is a very challenging task because most of these lawyers do not have the legal knowledge, the knowledge of public international law issues. And therefore, our assistance to them in order to interpret and apply international norms is very important. Allow me to refer to a national example in this regard. Until last year, the applicable legislative framework in Greece imposed an obligatory recourse to Sharia law for the settlement of family and inheritance law cases within the Muslim minority in Thrace, northern Greece. Now, this framework that dates back years ago was last year amended, and eventually now recourse to a mufti, which is the religious leader of the Muslim minority in Thrace, or the application of the Sharia law in inheritance and family divorce matters is now only possible with agreement on all those concerned. And I believe this is a very important development, and the outcome was due to very intense discussions between the lawyers of the Foreign Ministry with the lawyers of other sections, the Council of State, that is the agent of Greece before the Human Rights Committee, the Court of Human Rights, and also other lawyers like from the Ministry of Education and Religion. But allow me to say that the efforts of the legal advisor of the Foreign Office was geared towards harmonizing the interpretation of treaty provisions, which date back to the beginning of the century, with contemporary human rights standards and minority standards. And I believe that we achieved that. And much weight was placed on countries' compliance with human rights law. The legal department is also engaged in multiple discussions with foreign legal advisors on international law issues, both at the bilateral and international level. Ian already gave us a picture of what these kind of contacts are and how useful they are. At the bilateral level, we are engaged with our foreign colleagues in the context of negotiations of bilateral treaties, for instance, maritime negotiation conventions, and this is a very difficult exercise, I might say, and sometimes during these negotiations we get to know better what is the belief of these states about the law of the sea provisions and how they interpret the law of the sea provisions, and this is mutually beneficial. We also engage in many discussions informally with our foreign colleagues. And during these informal discussions also we get to know better the perception and the interpretation they make about international law provisions and norms. And during these discussions, people openly speak to each other, and these are very useful settings in order to better understand how these people feel about international law. I have to say that in some cases, the feedback we receive from during these kind of discussions result even in revisiting the legitimacy of a given national conduct, or even in revoking it. And let me give you another national example. Recently, the government decided to repeal the imposition of a special financial contribution to the international civilian staff of an international organization which were fiscal residents of Greece. And this actually was an action that brought Greece in conformity with its legal obligations, treaty obligations. But this was, again, the result of intense negotiations with the legal advisors of this organization, intense negotiations, exchange of notes. So you understand how important it is to have this kind of interaction with our foreign colleagues. At the multilateral level, we are actively engaged with our foreign colleagues in the context of multilateral meetings. Such meetings provide, in my view, a unique platform for a dialogue, an in-depth dialogue among legal advisors regarding international law and recent challenges that this law is facing. International Law Week is, in my view, the most interesting forum where such dialogue is carried out. And we both participate in these discussions, in the side events, and all the interesting discussions and conversations that take place. ACP, I think you will agree with me on that these annual sessions in the context of ICP are very useful, and it promotes actually our mutual understanding of many issues related to the ICC. During these meetings, I myself benefited from the contacts I had with our colleagues from the African Union, and I learned a lot about the real concerns behind. The ICP is also a forum where the legal advisors can informally exchange views about the implementation in their domestic legal order of the Rome Statute. For instance, I learned a lot about how others are criminalizing at the national level offenses under the jurisdiction of the court. And a typical example here is the crime of aggression. In the Council of Europe, in the context of CADI, we engage in a real dialogue with not only participating states, but also with observer states. And we hear a lot on how other states, how the national practices of other states, like case law regarding immunities of states in international organizations, immunities of special missions. And I also would like to stress that what is really important, and I believe, Ian, you agree with me, is the examination of a list of problematic reservations to international treaties, not only within the context of the Council of Europe, but outside the Council of Europe. Because in this context, in this setting, you hear what other states believe about these reservations and whether an objection is needed. You also hear the reasoning in support of such an objection. And this has facilitated a lot, many of us. For instance, in the case of my country, previously we believed that objecting is a hostile activity against a foreign state. Now, listening to others and the reasoning that they put forward regarding problematic reservations and their intention to object, we have made the same. We followed their example. COJUR, of course, is a privileged club of lawyers, and they coordinate and they discuss common problems, and sometimes they find solutions to these problems. But I believe that coordination discussion in this forum is quite easy because we share the same legal culture and same traditions. So I think what is really important, and here I want to conclude, is that the legal department of the Foreign Ministry is very often called upon to identify the international obligations and commitments assumed by Greece, especially on a particular issue, to clarify the scope both at home and to the other sectors of the administration, to ensure consistency between different types of treaties, and also to assess the compatibility between national law and treaty commitments. I would like also to mention that in doing so, we very often make an interpretation of the relevant norms on the basis of Vienna Conventional law of treaties in a way to not to tie the hands of the policymaker, of the political authorities, but allow them a certain margin of maneuver on how best to comply with the international norms. Moreover, our interaction with our foreign colleagues and civil society broadens our knowledge and our understanding of international rules, and this in turn influences the legislator and the policymakers. In short, we are people who care about international law, as Michael Wood would say, and we do our utmost to bring international law home. Thank you very much.
Well, thank you so very much for your presentation, which wonderfully complements that of Ian MacLeod, with similarities, but coming at things from slightly different perspectives and practices that may be in common, but one of you has dealt with rather than the other. Well, now we'll turn to a focus more on the international judiciary and domestic judiciary and how they engage with international law. And we'll start with Judge Eicher of the European Court of Human Rights. Tim.
Thank you very much, Rosalind, and thank you very much for the organisers for having me. It's a great privilege to be here. in your opening remarks, you mentioned the hat we are wearing. And of course, for me, I've been at the court now for 3 years, and I spent my previous life as a litigator, including in matters of international law. And one of the things that struck me about the engagement most forcefully in my new role is that certainly as a litigator, I traded in arguability, and now I've got to get it right. And that's quite an interesting difference in approach. Now, when I was confronted with the topic of engaging with international law, it was a curious sense of not quite sure how to address it, because, of course, we are an international court set up by a treaty and charged with ensuring the observation of the obligations under that treaty and by way of an advisory opinion under the Oviedo Convention. So I thought, well, how do I best address this topic here? And one way, of course, would be to go into the substance in detail. After all, in 2015, the Steering Committee for Human Rights of the Council of Europe identified the place of the European Convention in the European and international legal orders as one of the areas which it considered to be, and I quote, decisive for the long-term effectiveness and viability of the Convention system, end quote. Now, that's been a work of experts has been working on that topic of the member states, I should add, have been working on that for some time, and only last week considered the latest version of the preliminary draft report, and that runs to about 140 pages, so I thought that would probably blow the framework of my 7 minutes. So I just wanted to make a few points on the substance and then perhaps reflect a bit on the practicalities. As I said, we are an international court charged with ensuring the observance of undertakings undertaken by member states under the ECHR. And Vaughan Lowe mentioned issues such as admissibility, etc. So we, in fact, engage with international law right from the beginning because our admissibility requirements are ultimately those which are familiar to any public international law, to just satisfaction under Article 41 at the other end, which we, in the case of Mohammed, under Article 46.6, have in fact placed very firmly within the framework of general international law too. And in the middle, there's a lot of engagement and having to negotiate our relationship as a specialist court with general international law. And Mr. Lelian mentioned earlier the Greek case of Molla Salih, which is the case about Sharia law, and that was a good example very recently where we as a human rights court were confronted with, well, how does the convention sit with the law on the protection of minorities, which was designed by the League of Nations? And, that's where we're confronted with this day in, day out, whether it is that or whether it is the relationship to IHL or questions of jurisdiction, etc. Now, another point which is probably worth mentioning, and Vaughan made the point about proliferation of information. Now, as I said, we have a very small legislative base, which is the convention, and then our jurisprudence. There are now more than 22,000 judgments of the court, and last year we handed down more than 1,000 judgments, and that's not counting our admissibility decisions. Now, even to stay on top of our own case law is therefore a challenge, and therefore staying on top of general international law and developments in other tribunals, etc., is equally a challenge. Now, when we look at how we approach, as a court, international law, general international law, we're clear that it is not our role to supervise the respect for other international treaties, but we look to achieve a combined and harmonious application of the Convention with those other instruments to avoid a conflict or opposition between them. And I mentioned IHL, and the case of Hassan is a good example where the court tried to engage with that. Now, there will be areas where that may not be possible, and that's where, and this is largely arisen in the context of EU law, and I appreciate there's another argument to be had in how far EU law is general international law, where we then apply the so-called Bosphorus presumption, i.e. if this regime, which we think we are in, possibly in conflict with, commands a certain behavior and the system protects fundamental rights in an equivalent way to the Convention, insofar as a state has complied with its obligations under or the requirements of that law, we will assume that it has not departed from the requirements of the Convention. But then, and you'll all be familiar with the Al-Dolimi and Montana management case, where the outside world might have said there's an obvious conflict between the ECHR and general international law, and the court, dare I say it, sidestepped that by not recognizing that there was a conflict between the duty imposed under UN Security Council resolutions to freeze without delay the assets of identified individuals, and therefore did not consider that it had to take a view on the primacy rule in Article 103 of the UN Charter. And it based that on the presumption that the Security Council cannot have intended to have breached fundamental principles of human rights unless they said so in the clearest and explicit language, which the court did not find expressed. But you will have seen a clear example of the three approaches in the separate opinions of my colleagues, Judge Keller and Judge Nussberger from Switzerland and Germany, respectively. Judge Keller found a violation, but did so and said it would have been more appropriate to do so under the Bosphorus presumption on the basis that the UN system did not adequately protect, and therefore there would have been a violation. And my German colleague took the view that, in fact, once there was a conflict identified, Article 103 required there to be a finding of no violation, because the need for a convention interpretation led to the inevitable and determinative application of the express regulation of Article 103 of the Charter. How we will deal with the case where we have to acknowledge a conflict remains to be seen, and I'm not aware of a case that currently raises the issue, but I won't say any more on that.
This time.
Now, but how does that work in the day job? And there is, of course, an issue about us being a specialist and regional human rights court, where there are some very important structural differences. The first is that with the very few exceptions and the current interstate cases between, for example, Russia, brought by Georgia and the Ukraine against Russia are the exceptions. The applicants before the court are private individuals or companies rather than states. In most of the cases, we are concerned with how states treat their own nationals rather than those of others. And that leads to a second difference, which I think, compared to other international tribunals, is noteworthy, and that is the size of our docket. We currently have some 62,000 cases pending, and therefore our workload and the ability to engage in great detail with every issue is informed by the fact that we have 47 judges who have to deal with 62,000 pending cases. The other issue about it is that cases come to us sometimes without a noticeable change of mindset by the applicants, by the lawyers, be it applicants or respondent governments, because frequently our proceedings appear to be no more than a continuation of the domestic proceedings. And that influences how cases are brought before us, despite the fact that we have repeatedly said we're not a fourth instance court, and therefore it is not our role to second guess the interpretation and application of domestic law, and we will really only do that where it appears that that interpretation is arbitrary or manifestly unreasonable. So that's the way cases come to us. If you then look at the body of judges who sit on it, of course, Article 21 of the Convention doesn't make knowledge of public international law a requirement. The Parliamentary Assembly has made it a criterion, but it is not in the Convention. And therefore we do have a situation where the primary focus, understandably, is on the international law as it relates to human rights, rather than general international law. And we have a number of very good and prominent public international lawyers on the court, and our president, the Greek judge at the moment, is one such example, Professor Sicilianos. But it also means that there are members of the collegiate body of judges whose background may not be strongly in the general public international law, but are more human rights focused. And that is, I think, where the role of the parties in our engagement is so important, because it is the way the parties present a case and plead a case, it is the interventions we have which help us to engage with public international law as a court. And it is perhaps worth noting that in doing that, there are various points of contact. The first is the registry lawyer, and it depends on how far their role, their understanding and training goes into general international law, who will look at a file first before it is assigned to a judicial formation. The next point of contact is the judge rapporteur. Again, the question arises. And then we have the other members of the composition who receive the case for the purposes of deliberation and decision. And at each one of those stages, an alertness and an alerting to issues of general public international law is important. Ian MacLeod mentioned the issue of dialogue between legal advisors, and I think there's an increased recognition by the courts too, certainly by my court, that actually dialogue is fundamental in order to ensure a harmonious and as harmonious as possible interpretation of public international law as a body of law, which is why there is increased dialogue, primarily for us, between us and the domestic courts, but also to some extent with the International Court of Justice, with the International Criminal Court, but also with the UN human rights mechanisms and the other regional courts as well. And they assume an ever more important role. And Vaughan Lowe mentioned the question, how will we engage and how much we rely on, for example, the UN treaty bodies? And I think we do increasingly take great note of what they do. I must say more in the context of their quasi-judicial role than in their monitoring role under the 4-yearly cycle. But that is because the role is a different one.
Yes.
But we do increasingly take their role. The other way we are alerted to and we engage with public law is, as I said, through interventions. And we've had very helpful, both written and oral, third-party interventions from various bodies, including UNHCR, the UN Special Rapporteurs, the EU Commission, and others. Internally, we have a research division which backs up the court, and therefore if an issue is flagged up and it raises novel issues, research reports will be drawn up to assist the court to deal with these matters. But we are a collegiate body in the Grand Chamber of 17 judges. It is, I think my message is that we need to be alerted to these issues. We will raise them pro motu if they are not raised before us, but that then really depends on who has conduct of the case at what stage and how alert are they to that particular issue. But if we do, the mechanisms are there, both through, on the individual case, through the research division and knowledge sharing, which we have in-house, but also more globally through our dialogue with other courts, international and national, to help us engage with international law as the European Court of Human Rights. Thank you very much.
Thank you very much. Many thanks, Tim, for sharing these insights and explanations with us. And now over to Professor Reagan, and I think she may talk to us primarily about how our topic looks from the perspective of a very important national court, but she has carte blanche to cover what she wishes.
Well, thank you very much, Dame Rosalind, and thanks also to the organisers for inviting me. It's a great honour and pleasure to be here. As Dame Rosalind intimated, I thought in the 7 minutes I might pick one of the hats that I've worn in relation to international law rather than talking across a range of them. And looking at the composition of the panel, it seemed to me that the one that would be an important hat to contemplate would be the role of a national court in engaging with international law. So I served on the South African Constitutional Court, which was established, the only court established immediately following the transition from apartheid to democratic South Africa, and it was set up effectively at the apex of the system. Now, there is no doubt that when you engage with international law from the perspective of a domestic court, one brings or one looks at international law through a different lens or different prism to how you do it when you're serving on an international court or tribunal. But it seems to me that not only is that so, but in many ways it depends from which national court you are looking at international law as to how you're going to deal with it. And the South African situation is a particularly idiosyncratic one in a sense. Firstly, one can't really reflect on the South African Constitution and the South African Constitutional Court's engagement with international law without remembering the apartheid history and the role that that played, or that the role that international law played in relation to the policy of apartheid from the 1960s onwards, really. The international condemnation of the policy of the apartheid state, the eventual determination of apartheid as a crime against humanity, and of course South Africa's suspension from its right to sit in the General Assembly are all important background to understanding where we are today. And they informed the drafting of the Constitution. If you read the preamble of the South African Constitution, one of the core principles it states is that South Africa, now in its new democratic state, is going to be taking its rightful place in the family of nations, and that open and outward-looking attitude to international law runs through the Constitution. So if one thinks again about this lens which domestic courts are bringing to look at international law, the first question, or the first thing to note really, is that by and large national courts in most cases are determining rights and obligations based on domestic law. That's the job of domestic courts. And understanding what the relevance of international law is going to be to that job really requires you to start with understanding what the relationship between international law and domestic law is. And in the South African context, the answer to that question is provided in the constitutional text itself. And it provides that customary international law is law in South Africa, save if it conflicts with a provision of the Constitution or legislation. So by and large, a monist system in relation to customary international law. And then it goes on to say that treaty obligations and provisions of treaties will only be binding in domestic law if they have been enacted into law by Parliament. So by and large, in relation to treaty obligations, we have a dualist system. Perhaps even more importantly than those two provisions, the Constitution creates two strong interpretive rules which require courts to look at international law. Firstly, when interpreting the Bill of Rights, the Constitution says that the provisions of the Bill of Rights must be interpreted, or international law must be taken into account when interpreting the provisions of the Bill of Rights. On one hand, that seems like a very strong interpretive injunction to courts. Of course, it is an injunction simply to take it into account, international law into account. And there are really two things to note about this. Firstly, the court has taken the view that it is not only international law that is binding on South Africa in the international sphere that must be taken into account, but any international law, including soft provisions of law, non-ratified treaties. And there one immediately comes across the problem that Vaughan Lowe spoke about, which is proliferation and pervasiveness. There is an enormous amount of international law in relation to many of the rights in our Bill of Rights. And I think it's in some ways a very difficult challenge for the court to know what to select, what not to select. It depends to some extent on the quality of the argument put before them. But this open-ended approach that the court has taken to international law in some ways becomes very difficult to apply in practice. So that's the first interpretive principle. The second one is an equal obligation upon the court to seek to find interpretations of national legislation that are consistent with international law. Now, again, the same phrase is used, international law, the same term, but actually in practice the courts have generally said when we're looking for the purposes of interpreting legislation, we will look only at binding provisions of international law, so treaty obligations or customary international law that are binding upon South Africa in interpreting legislation. But if one looks at the work of the court, it's these two interpretive provisions which have been one of the great doorways for the engagement with international law. It's not really possible to give you a kind of overview of the extent to which the court deals with international law in its judgments, but I can say that it is extensive, and it's probably extensive not only for the reason that the Constitution requires it, not only for the reason that international law now affects so much of ordinary life, and if you're going to be interpreting and applying human rights, obviously international law, there's an enormous amount of international law there, but in a whole array of areas, whether it's international investment or copyright law, there are a whole array of areas in which the court has had to engage with it under the interpretive principles. So one sees there that the court is using it extensively. But it also seems to me that international was being used in another way by the court, and that is really to enforce the Constitution's own commitment to human rights and to the accountability of the executive. One of the areas which has been particularly topical and high profile in South Africa has been the question of withdrawal from treaties. That has been, of course, somewhat of an issue here in the United Kingdom as well. And in South Africa's case, the two treaties concerned was firstly the Rome Statute of the International Criminal Court. Some of you who follow the events in the International Criminal Court will know that South Africa gave notice to withdraw from the Rome Statute some years ago. It followed on a visit of former President al-Bashir to South Africa, and both the visit of former President al-Bashir and the attempt by the executive to withdraw from the Rome Statute resulted in important decisions of the Constitutional Court, of the courts. In one case, the Supreme Court of Appeal, and in the other case, the Constitutional Court. Although international law was extensively considered in both those judgments, they both actually went off at the end of the day on national law principles. In the first case, in relation to President al-Bashir, the court held that the government's failure to arrest President al-Bashir was in breach of the statute which South African Parliament had adopted in following on the signature and ratification of the Rome Statute, which required the court held the state to arrest even a sitting head of state. And so it didn't deal with the head of state immunity, or didn't determine the head of state immunity finally in relation to international law. And in the second case, which was when, following on that decision, not very long after that decision, the executive gave notice in terms of Article 127 of the Rome Statute to withdraw from the statute, that decision was challenged before a court in which the court held that the notice was not competent within the South African constitutional framework, which would not allow the executive to give notice without first getting ratification of Parliament. So these issues around withdrawal from treaties have been extremely contested and sensitive in South Africa. And I think it's an interesting question as to whether we are seeing, as a recent book by Eyal Benvenisti and George Downs has argued, a greater sense that courts are not as deferential, perhaps, to views of international law and the conduct of foreign relations towards the executive as they may once have been, whether that is seen in South Africa. And I think it's arguable in relation to the withdrawal cases, and it may be arguable in other areas as well. Benvenisti and Downs argued that the reason for the national courts with sort of reduction in deference lies, in a sense, in a position domestic courts are taking in relation to the extension of patterns of globalization. I don't think that is really the argument one could make in relation to South Africa. I think to the extent that one is seeing perhaps a questioning at times of the position taken by the executive in relation to international law in the South African courts, it's really founded on the constitutional principles of respect for human rights, the rule of law, and holding the executive to account, rather than any considerations of from the international or global sphere. But there's no doubt that, just as Vaughan Lowe said at the outset, that the practice of international law has changed in an international law environment. It has changed dramatically in domestic courts in South Africa since I first trained as a lawyer in the 1970s. And I think that is a global phenomenon. It is interesting then that, in fact, We don't require judges to have done an international law course. In South Africa, it's not part of the compulsory syllabus, something I think that arguably conflicts with our constitutional commitment to engagement with international law, and one hopes that that will be something that will be reconsidered. But despite that, I think one is often fortunate sitting as a judge in South Africa to have high-quality argument put before you by counsel, and I think an obligation on the courts flowing from the principle, particularly in relation to customary international law, but even in relation to treaty-bound obligations, where they clearly form part of the law of the country in terms of the constitutional provisions, for courts to erase the issues propria motus, as Tim has mentioned, and so it is important that judges of the courts remain familiar with not only the principles of general international law, public international law, but also of the extent to which South Africa has undertaken obligations in the international sphere. Thank you.
Thank you very much.